And welcome to tonight's edition of the One Hood Power Hour. I am your co-host Kahari Mosley here with my trusty partner Miracle Jones, and we have another great episode tonight. We're going to be talking about PA Senate Bill 913, a bill that was originally framed as kind of criminal justice reform around probation, but in that legislative process, the sausage making, as they call it, a lot of things came out where, it really looks like it would have actually a detrimental impact on those in the criminal justice system, on probation, clear themselves, of the system and move away from the system. It has many provisions, which we'll get into tonight. We have a wonderful panel of experts tonight to talk about that. We'll get into that in a little bit. But before we get into Senate Bill 913, we do want to get into some headlines. And the first thing I wanted to mention is we've been talking for a number of weeks about redistricting the maps. And excuse me, recently, we've now are at a place where the Department of State is suggesting that the normal 21-day period to circulate petitions is potentially being truncated down to 12 days. In some cases, I think there was one proposal to have a 9-day period for those running for state offices such as state rep and state senate. There's still some uncertainty around that, but there has been comments made from candidates, including a local candidate that we had on the Sunday night sit down, Latasha Mays. Many candidates are expressing frustration, with the process and the truncated period, particularly for those running statewide, where you have to get a couple thousand signatures, and then usually you have to reach a threshold in a certain amount of counties as well. So when you're running statewide, it's generally not just the 2,000 votes you need, but you usually need, I think, 100 from 10 different counties or 5 different counties. I forget the exact threshold that you have to meet, but it is a high bar. And in a truncated period of time, it could pose numerous problems for candidates around the state.
Yes. And again, we know that this is a quote unquote once in a lifetime event that's happening, with the census, with the redistricting, with losing congressional districts and everything that's happening. But these changes will actually impact elections for years to come, because then they become the new default rules. And so we're trying to make sure that our electorate is as representative as possible. It's always an issue when these timelines become more truncated, and there's a reduction in the ways that people can actually do outreach. And so when we're trying to make sure that people are able to be involved and engage the political process, it's very necessary to keep these lines of communication open and to make sure people have as much time as possible to collect signatures, to go door to door, and to knock, especially if there isn't, a personal multi-millionaire fund or organization backing some of the third party and independent candidates. So it's going to be a very interesting week when it comes to the maps. Hopefully, the majority of the maps will be solidified by this week. We're hoping, and we can go ahead and get this election 2022 underway. If not, we'll still be back here every Monday talking to you about what is happening in this area. But I'll also say today was it was an opportunity for Kahari and I actually to engage in some direct action to support the family of Peter Spencer this afternoon, who are calling for transparency and better communication into the investigation about what led to the death and murder of Peter Spencer. So that was something we were able to do this afternoon. In addition to what's going on, there are still situations going on nationwide when it comes to electoral organizing, and we are trying to see what's going to be happening again. In the rarest occasions, we have a lot of cases before the Supreme Court locally, before the actual Supreme Court of the United States, and we still have pending voting rights legislation in front of our federal representatives. So we're hoping maybe, if not by this primary, by the November elections, we'll have expanded voter protections. But again, everything is up in the air, and everything, unfortunately, unprecedented is the word for the year still. And so, but also on top of that, this year we're actually seeing the change in COVID-19 safety protocols. And so a lot of states have started to actually lift some of their mask mandates. And we're going to be seeing, hopefully, more people engaging around support for those impacted by COVID-19 as these mask mandates change. But we're also know that these numbers are not looking good. People are still testing positive for COVID-19, and people are still unfortunately passing away of COVID-19. Yet, if you've been paying attention, I guess I'm going to hand this over to Kahari to talk about some of the ads that COVID-19 has led to this PA Senate race, and how it's really, really becoming an issue that is going to unfortunately stay with Pennsylvanians for at least the next 6 months.
Sure. If you live in the greater Pittsburgh area and think there has been a disproportionate amount of political ads already in the season, it is not just your inclination. That is the truth. A Pittsburgh market has seen the most ads in this cycle so far. From Super Bowl, the Let's Go Brandon ad during the Super Bowl, to Dr. Oz, to McCormick, to the whole range of candidates that are running. And it shows that between November, and last Tuesday, there's just been a ton of money spent from you know from both from not only candidates but also from super PACs. I was saying that it's pretty incredible the amount of money that has been spent so far. There's super PACs for candidates. There's a super PAC against Dr. Oz. There's just going to be so much money spent, and definitely has been a lot of ads attacking Dr. Oz so far in this cycle, and we can expect many more. COVID claims, false COVID claims. So I mean, we're gonna have a lot. If you don't like political ads, I have bad news for you. You're gonna be seeing a lot of them, not only between now and the May primary, but maybe you might get a little bit of reprieve over the summer. But this spring and this fall will definitely be probably the most television ads you have ever seen in your life, and I'm sure for most people, that is not something that gets people excited. But we feel it is our civic duty to let you know and to be prepared to maybe use the mute button, or keep the clicker close so you can change the channel if that's not your thing. But if you're watching the 100 Power Hour, you're probably into political ads. But we still feel it's our duty to let you know. We also want to give a shout out to our ASL interpreter who joins us every Monday night. Cameron, thank you so much for everything you do. And Miracle, is there anything else on the headline front that we want to talk about before we dive into Senate Bill 913?
Yes, again, a lot of organizing is happening for many issues, and we know COVID-19 has been very politicized. So we still are keeping our eyes about what's going on in Canada at the border. That is a looming, unfortunately, international crisis about the response to COVID-19. In addition, we know the situation that happened in Portland over the weekend, and so as we are going back to warmer weather and people are still engaging in civil disobedience and good trouble, is to make sure that people are staying safe or staying active, understanding that there are various entities, some with ties to white supremacy and fascism, who are also out here protesting and organizing, just reminding people to stay safe and to stay diligent, because there's a lot of things that unfortunately happen. But, also, right now, and a little bit of local news before we turn to our guests. The Guinea transition team, to which Kahari and I are a part of, some of the committees, are hosting um, events and listening sessions, and in addition to doing the survey. So if you have ideas about what's going on in the city, if you have ideas about how to improve the city, how to make it more representative of the people, how to have better legislation, please make sure you take some time to fill out the survey and to reach out, because April's coming down, and we really want to make sure we have the most expansive and representative recommendations to put out. And with that, I will turn it back over to Kahari, who's going to talk a little bit about our guest and why we do these legislative visits.
Yeah, thank you so much. And there was just one other thing that I did want to mention, just about the U.S. Senate race. Um, there was a great article in the City and State that we're going to drop in the chat about just the number of endorsements that have been stacking up. And one of the things that I did want to point out, without um, you know thumbing the scale for one candidate or another. But I do think one of the stories that has to emerge from the primary so far is, the performance of Malcolm Kenyatta, the state representative out of southeastern Pennsylvania. In this article, it talks about the various um, uh, endorsements that he's received. I think many more than a lot of folks expected. I think, just to be blunt, most political observers didn't expect Malcolm Kenyatta to still be in the race at this point. Even though he's very impressive, very has done a lot, has a national profile, has developed a base. As a candidate, I think it is a very impressive, like the amount of support has created, and the amount of energy that he's developed around his candidacy. I think it's going to be something to continue to watch, particularly with Val Arcus suspending her campaign very recently, which leaves the two candidates from Western Pennsylvania, of course, Lieutenant Governor John Fetterman, Congressman Connor Lamb, and now State Representative Malcolm Kenyatta. So that's going to be one thing I'm going to be watching throughout the primary of this story of this candidate. People didn't give a lot of hopes for when he announced in 2021, but now it looks to really be positioning himself as a very legitimate candidate in this race, particularly given the fact that so many more votes in a primary election are going to be out of southeastern Pennsylvania, which now he is the only candidate from southeastern Pennsylvania on the Democratic side. So I just thought that was something very interesting from a political observation point of view.
Yeah, and again, the Senate race is one of the most expensive races going on, and it's great to see that more people are in tuned. Unfortunately, that does mean we're going to have a contested long 6 months ahead of us, and we said it last year, gone are the days of us understanding and knowing who our elected officials are at the primary. These are really contested races. Pennsylvania is in play, and there's so much at stake. So it's going to be really cool to see who is going to be walking away with some of these legislative wins. And we're about to talk about now why it's so important for people to vote and use organizing and electoral organizing as a strategy and a tool in their tool belt, because when we talk about the bills that are being passed and how they impact people, even if they start with the best intentions, a lot of times, as Kari says, that sausage making process creates, unfortunately, sometimes more barriers. And with that, we're going to turn it over to Kahari to talk about why we do legislative visits, and then we're going to bring in our guests to talk about this new Senate bill.
Thank you, Miracle. Yeah, once a month, we take an opportunity to take one episode and really focus on a singular piece of legislation or a singular policy issue, but generally a singular piece of legislation to provide some education to the public, as well as really deep dive into policy with policy experts from around the state. And tonight is no different for our legislative visit for the month of February. We're very excited to delve into this conversation about proposed probation legislation, Senate Bill 913, with Elizabeth Randol, Legislative Director of the ACLU of Pennsylvania, and Dolly Prabhu, the staff attorney of the Abolitionist Law Center. So welcome to the One Hood Power Hour for our deep dive on Senate Bill 913.
Thanks for having us.
Thank you so much. So we're gonna have Miracle start off with the first question.
Yes, and so like we talked about a little bit earlier, bills come down, the sausage making process happens, and a lot of things are put into legislation that people are not aware of or that actually creates a lot of harm. And so, Dolly, can you just talk a little bit about SB, 913, the history and the original intentions of the bill, and how do we get to this moment now?
Yeah, sure. I mean, I'll start by first. I don't want to assume, everyone's watching has all the background knowledge about probation that we do. So maybe I'll just back up and just start by explaining probation and how it functions so that the context of the bill makes a little bit more sense. So probation is, of course, a form of community supervision. People confuse it often with parole, but they are pretty distinct. So probation is a sentencing decision that's made by a judge, and it's imposed in lieu of incarceration rather than in addition to incarceration. Whereas parole is an alternative to continued incarceration, and it's an administrative decision made by a parole board to release someone to community supervision before the end of their maximum sentence. There are some similarities, however. Of course, you're supervised by a probation officer or parole officer. There are conditions of probation and parole you have to adhere to. And importantly, if you violate those conditions, you are subject to reincarceration. So for probation, what that can look like, since that's what we're talking about tonight, is that if you are found to have violated your probation, a judge can decide, has a couple of options. They can either decide to take no action at all. So even though you have violated your probation, they can still allow you to continue probation. Or they can do what's called revoke your probation, which essentially means your probation is terminated early because and although that sounds good the way I said it, what happens when your probation is revoked is that a new sentence is imposed, usually a sentence of probation, but it can actually be a sentence of incarceration up to the maximum of whatever your underlying crime would have allowed. So that's kind of a very basic overview of probation and how that system functions.
Thank you so much. I think it's very important to have the background information. And so now that we have some of that language down, coming to you, Liz, can you talk about why people consider Pennsylvania to be a probation trap here in Commonwealth, and how does that differ from some other areas?
So a couple of things, I think people sometimes think of, perhaps not in this audience, but that Pennsylvania might be a more progressive state or might be ahead of the curve just based on where we are geographically, but we lag behind most other states. And specifically, we lag behind in the realm of probation sentences. So we are one of the very few states that does not limit or put what we refer to colloquially as putting a cap on probation. So the only limit to how long you can stay on probation in Pennsylvania is, sort of as Dolly had referenced earlier, the statutory maximum of the underlying offense that you have been convicted of. So depending on how long that is, it could be several years or decades. So in Pennsylvania, we are definitely backwards in terms of not limiting probation sentences. We also allow for judges can stack sentences, which means that they can impose multiple sentences of probation back to back. And so, which adds obviously longer periods of time to someone's probation sentence. And then Pennsylvania also allows judges to impose what they refer to as a split sentence. And so a split sentence is when a judge might sentence someone to a period of incarceration. So you go to prison or jail for a period of time, and then after you have completed your sentence of incarceration, you will then have to spend some number of years on probation afterwards. And so this just extends the penalties and the punishment for even longer, and can become very confusing. Dolly had mentioned a little bit earlier that there are conditions for both probation and parole. And those actually are different in some circumstances. And so someone might be incarcerated for a bit. They could be released on parole, have to adhere to certain conditions of parole, and then have to move to being supervised under a probation sentence, which has different conditions. So those are a couple of the primary ways that Pennsylvania lags behind in terms of how our probation system functions. But I did want to mention, if you wanted to put up that graphic just for a second. So I made a little handy graphic, because a lot of these terms I think can be a bit confusing, and it's a lot of information, but we sort of refer to probation as it's a trap that people get sucked into. And I think it's important to underscore the fact that probation was originally intended as a type of penalty that was meant to serve as as an alternative to incarceration. But in fact, in Pennsylvania, the way that our system is structured actually fuels and feeds our mass incarceration crisis. And so what happens is that someone gets sentenced at the beginning. You can to a period of probation, whether just the initial sentence or one of multiple sentences, a stacked sentence or a split sentence. People spend many years on probation trying to adhere to some of the burdensome conditions that they have to abide by in order to not violate their probation, many of which we refer to them as rule violations. So these are violations that are not themselves criminal activity. These are things that otherwise are not, missing an appointment, leaving the boundaries of your county. So otherwise, these would not normally be criminal activities, but if you're on probation, they are. They can be punished. So you spend enough time, you slip up, you violate your probation. You can then have and I'm going to have Dolly talk a little bit more about detainers, but you can have a detainer lodged against you. So that's when you're sort of held pre-trial while you're waiting to find out what the judge wants to do as a result of your violation. If the judge decides to revoke your probation, then this is where the trap sort of comes in, really, which is the judge can revoke your probation, and then if you get resentenced, you don't get the time that you spent already on probation doesn't count. So you can be resentenced all over again for the same offense over and over and over again. And often that leads to periods of incarceration. And so it is very difficult to get out of probation and to get off of it without tripping up on one of those conditions. getting detained, having your probation revoked, and then being incarcerated. Dolly, I didn't want to. I don't know if you wanted to talk a little bit about the. I know you wanted to mention some of the uptick in the splits, and then also some of the how Pennsylvania is just really wretched with its detainer process.
Yeah, no, I can definitely jump in. So, like Liz mentioned, there is an issue in PA with not having caps and with allowing what's called stacked sentences, so consecutive back-to-back probation sentences, rather than allowing probation to be, or the judge has the option to impose consecutive sentences. There's also the problem of split sentences. So in PA, split sentences are permitted, which is a sentence of probation, a sentence of incarceration that is followed by a period of probation. And these are becoming more and more common, and that's important because we hear often about probation being an alternative to incarceration, but instead it's being imposed in addition to incarceration. And so it's really becoming an alternative to freedom, not an alternative to incarceration. And a quick example of that I observed in a probation violation hearing in Allegheny County is that in one case, there was an individual who had been on probation for a really long time and had recently been convicted of a new crime, and the judge was about to sentence him to a new period of probation, and he actually asked for incarceration instead, because having moved through the system, he knows that even if he's sentenced to probation, he might end up spending even more time incarcerated than he would have had he just been sentenced to incarceration immediately. In addition to that, probation comes with all sorts of onerous conditions, including needing to pay for fines, fees, restitution. These can be 6 or 7 figures. So people will be on probation for the rest of their lives trying to pay these amounts off. And in his particular case, he knew that he would have to go to what's called a DUI hotel, which are mandatory classes for people who have been convicted of DUIs. That is over $1,000, and he didn't have the money for that. Which would have been a probation violation. So he would have ended up back in jail. So he asked for incarceration, and the judge replied, even if I sentence you to incarceration, I'm going to add probation onto it afterwards. So we see that, like this narrative of probation being a privilege or an alternative to incarceration, that's just not the reality anymore. And probation's actually feeding mass incarceration. And about detainers, which Liz mentioned, probation detainers are what's feeding our pretrial incarceration population. So probation detainers, like Liz mentioned, they mandate that people stay in jail pending their probation violation hearing. Unfortunately, their probation violation hearing can take months or even years to be scheduled. That's really common. And also, probation detainers trump bail decisions. So if you're determined to be bailable, even if you have bail set and you pay bail, you still have to stay detained. And that's why probation is actually it is the largest driver of pretrial incarceration in Allegheny County. 1/3 of our county jail is being held on probation detainers, as opposed to that's about 6 times the amount that are being held on cash bail. And I only bring that up because cash bail tends to dominate a lot of conversations about pretrial incarceration. And of course, it's an important issue, absolutely needs to be abolished. But unfortunately, even if it ended tomorrow, unjust pretrial incarceration would still exist in large part because of probation detainers. So that's kind of my little spiel about probation detainers, and that's how probation feeds mass incarceration in our county and in jails and in prisons.
I guess starting out with Liz, then back to Dolly. Can you just talk a little bit about how we got here? I definitely saw some news clips even going back to December, and some even headlines kind of heralding, the passage, of this is the Senate and in the state Senate and presenting it as some form of progressive criminal justice reform. So how do we get to this place? Can you walk us a little bit through the process of how this piece of legislation came to be and how it was framed as something progressive, but now, under deeper scrutiny, it has a lot of flaws and a lot of problems with it that you're, pointing out very, very clearly tonight. So how do we get here?
So look, there's no such thing as a perfect bill, and certainly if we have any chance of anything ever passing in the Pennsylvania state legislature, it's not going to be perfect, and it will not do all of the things that we would want it to do. There was an original version of this bill last session. It was also refiled, but it didn't end up running this session. We can provide you some more information on that. But last session, it was Senate Bill 14. In this session, it was filed as Senate Bill 5. And that was probably more of an ideal bill. It still wasn't completely perfect, but it did impose limits on sentences for probation. It eliminated the ability for judges to impose a split sentence and stacked, and limited or prohibited judges from stacking probation sentences. And it also provided for automatic early termination of probation after 18 months if someone had met the conditions of their probation and had not had any violations. And so it was a very clean, sort of simple way to limit or restrict some of what Dolly and I were talking about in terms of the runaway train that is probation in Pennsylvania. And so what happened, though, at the end of last session, I don't want to get too much in the weeds, but there was some amending of both a Senate and a House bill that had very problematic provisions in it. A lot of those provisions were duplicated in this session's bill, which is now Senate Bill 913, the bill we're talking about. And the biggest problem that we saw was, it's one thing to compromise on some provisions and to say, well, we can't get this, but maybe then here's the backup, we can get something else. But there were a lot of things that were included, some of which was drafted by the Pennsylvania District Attorneys Association that got into the bill, that really ends up sort of doing a bait and switch. It's a little bit of a Jedi mind trick. There are things where the bill looks like it's making some reforms, but it's really doing a reform and replace. It's replacing sort of one broken system with another. And in doing that, is adding new language that we fear will invite additional problems or cause judges to behave or invite them to behave and make decisions in ways that would actually be worse than how probation currently operates. We don't tend to have a lot of trust or faith that the actors in the criminal legal system are always going to behave in ways that are to the benefit of Black and brown people and indigent defendants. And so, we worry anytime we see expanded powers for, discretionary decision making, et cetera. And I can go into some of the details about that. But I think, it's important to understand that we are not, I think a lot of the conversation in the Senate when it passed was that people were supporting it because they were saying, look, that we don't want the perfect to be the enemy of the good. Something is better than nothing. Okay. But that only works if the something is good. We don't have to have all the things. We don't have to have every single thing on our list. But if you are providing really none of the things on the list, and then the things that you're adding are creating additional problems, then it's not something is better than nothing. We would, we would argue that this is opening the door for a lot more problems than we even had under our current system. So I want to make sure that it's clear that we're not being idealistic. We're not shooting for the moon. We shoot for the moon. We know we're not going to get it, but we're not being unreasonable. We'll take smaller changes that are a bit cleaner and easier to access, reforms that are easy for people to understand and to follow and to implement. And if that can't happen, and you add some bad provisions, then that's why we're taking issue with it. So if this was just sort of smaller changes, we'd probably be totally fine with the bill. We wouldn't be perhaps as excited, but this is a different animal. We're opposing it because we actually think it's doing additional proactive damage.
Yeah, and I'll just add on to that the bill, it might look good out of context, at first read, but if you understand how the probation system functions day to day and the idiosyncraticness of like from county to county, what's being proposed, like Liz said, there's so many limitations on even what sounds good that it's unlikely to help most people on probation, if anyone at all. And that's at best. And again, like Liz said, if that was the only outcome of the bill, we wouldn't be here spending our time pushing back against it as hard as we are. We're worried that a lot of the wording of the bill is actually going to create more harm than good as a net impact. And I can give a couple of examples and pass it on to Liz to expand into anything I've missed. But one example is that this bill creates a new form of probation, administrative probation, for folks who owe restitution. Restitution is a mandated repayment to some victim. Often that victim is a bank or a corporation, and restitution can be quite high. And so if you're on probation, this bill essentially creates a new form of probation for those folks, whereas the solution we would actually want is for those people to not be on probation at all. And actually that does happen now, where if you only owe restitution, judges do close out your probation if you've been making regular payments. And so we see that, if you just read the bill, maybe that sounds good. Like, oh, if you're on restitution, if you owe restitution, you don't have to do full probation. But actually, it's creating a whole new form of probation when what we want is for those folks to not be on probation at all. So that's just one example. Another example is that this bill proposes these early probation termination conferences, which again sound good, sounds like terminating probation early, but there are so many explicit limitations to who is eligible for these. And the process is so convoluted and confusing that one, even if it was easy to implement and everyone, including judges and defendants, understood what was going on in their bill, their rights, and how to enforce those rights, even then, so many people would not benefit from this. And what's worse is that early termination is already something that judges have the power to do at any point. And, often, I don't like complimenting judges often, but they do actually close out. A lot of them do close out probation early if people have met all their conditions. This bill, what it risks with this language is that judges will potentially now not terminate probation early, whereas they would have, because they think that there's a system in place they can fall back on that terminates probation automatically. But in reality, when you read between the lines, the eligibility is so strict, it's unlikely to assist most people. So this bill can be kind of tricky in how it presents versus how it would actually function in day-to-day life. And I'll pass it to Liz if you have anything else you wanted to expand on that point.
Yeah, I think I would just add, Dolly, there was an amendment made on the Senate floor where a new provision got added that would expand the power and authority to detain people on a probation detainer, potentially to police officers. The language is really vague. And so, of course, as we were referencing, Dolly was referencing before, one of the main feeders in our pretrial incarceration population are probation detainers. And so expanding some of that authority and power to detain to people outside of probation officers could be incredibly worrisome. And really, we were trying to imagine a scenario, what that might look like. And one of the things that we were discussing internally at the ACLU was, a situation where if a police officer were to pull someone over in, say, like wherever the police officer is working in a county, they run someone's information and they find out that the person is on probation in a neighboring county. They know that they've violated probation by crossing county lines. It's possible with this bill that the police officer could detain the person that they picked up while they made a phone call to the defendant or the person's home county to find out what their probation department wanted to do with the person that's detained. And so it would effectively sort of operate like a domestic ICE detainer in some way. And so, there are some provisions in here. We also think that there's opportunities, the way that the bill is written, looks as if it's limiting the ability for judges to incarcerate people for if they violated their probation as a sort of penalty for violating a condition of their probation. But what happens is that instead of eliminating the current provision that gives judges this huge amount of discretion to incarcerate people for a violation, it enumerates this list of proactive reasons. While it might look like it's limiting that list, we fear that it actually will cause judges to incarcerate people more, and that it might invite judges to incarcerate, and that the list is really almost as expansive and vague as the original one, as a current provision. And so again, I think Dolly and I struggle a little bit, and that's why we really appreciate, the being included on the Power Hour tonight, because this bill is, we are sympathetic to legislators who want to do the right thing. We want this. It pains me to have to oppose this bill. This is what we want the legislature to be talking about. This is the kind of issue and work that we want them to be doing. We don't get any pleasure or enjoyment out of pushing back against this bill. But it's because the probation system itself is very complicated, and the bill language is very complicated. And unless you have experience and sort of knowledge about how it works, how probation works right now, how it works in the real world throughout that process, and how this language will does very, very little to improve the current situation, and opens up a lot of additional doors for damages for making the system worse. It becomes a complicated bill to talk about and to sort of message on. And so we appreciate having some of the time here to expand upon some of those nuances.
I really appreciate it. You're talking about those nuances. I'm going to come to you, Dolly. Can you talk about a little bit of the racialized breakdown of probation, not only just in Pennsylvania, but also in Allegheny County? And we talked a little bit, Liz mentioned some of the list that can actually revoke. Well, can you just talk about, I think people sometimes think about, like, when you revoke a bond or a probation, you must have had to rob somebody. You must have done this like super like violent crime, and you're an active threat to society. But can you also just talk about some of the reasons why people can get a probation revoked?
Yeah, absolutely. So I'll start with that, and then I'll talk about the racialized breakdown, at least in Allegheny County. Like you mentioned, it sounds like we were talking a lot about what happens when you're accused of violating your probation. But what's some important context before that is talking about how easy it is to violate probation. So in terms of common probation conditions, there's the universal condition that you can't commit a new crime on probation, and that's what's called a direct violation. But there's all sorts of other conditions that can be imposed that by the judge, and those are all they may have nothing to do with criminal activity, and those are all what are called technical conditions. And if you violate those, it's a technical violation. And so that can include all sorts of things, like we talked about. Fines, fees, restitution, like paying sums of money. Those are conditions of probation often. So if you cannot afford that, you've technically violated probation. So if you're on probation for a year and you haven't paid whatever amount off, that's considered a probation violation. So that seems like a more direct relation to poverty, but there are a lot of indirect ones as well, such as like people are often mandated to take go to different treatment programs, like anger management classes, or the DUI hotel I mentioned earlier, but they're not told that they have to pay for it out of pocket and how expensive it is. So that becomes an issue. You also have to have an address as a requirement of probation, so you can't be homeless. Even the most basic probation condition, which is staying in touch with your probation officer, that usually requires you to have a phone plan. I have seen so many people who have been violated for probation and then incarcerated for months because they didn't have a phone, essentially. there's also a lot of overlap with mental health and substance use issues. There's a lot of unrealistic, like zero tolerance policies. So judges will put people on probation and say, if you consume any amount of drugs or alcohol at all, you're going back to jail. So because of that, I have seen someone go back to jail for months because they drank a Bud Light. So these are things that cause your probation to be revoked. So like you said, Miracle, it's not like Grand Theft Auto or anything like that. It can be just very mundane. You know, you were out past curfew. You weren't home when you were supposed to be, like very paternalistic things like that. Or it can just be a misunderstanding. But by the time it's cleared up, you spent months incarcerated waiting for your probation violation hearing. And then in terms of your second question, which is, you know, about like demographics and the racialized breakdown of who's on probation, I don't know off the top of my head national or state statistics, but I can certainly speak for Allegheny County. So I'll start by saying, you know, in a county that is only 13% Black, the jail population is 66% Black. And of the jail population, the folks in jail who are in there because of probation detainers, 66% of those individuals are Black as well. And then as of 2018, which is the date of the most recent report that probation released, as of that date, 43% of folks being supervised by adult probation in the county are Black. And, you know, in terms of why that is, hopefully it's not a surprise to anyone at this point that there are stark racial disparities in every single aspect of the criminal justice system, from arrest to bail decisions to sentencing. So the natural kind of result of that, I say natural, the unnatural result of that is that Black folks are more likely to be sentenced to probation, to be violated while on probation, to be detained pending their probation violation hearing, and then to have their probation revoked. In terms of like the actual stats, unfortunately, I don't have that because the county doesn't release that level of detailed information about probation detainers, but they should. And, you know, in addition to that, they should release information about which judges are supervising these folks on probation, because at the end of the day, it's judges who put people on probation, who decide to keep people on probation, who decide to violate people. So I'm sure if we had that data, we'd have a lot more of an understanding about why our jail population is 66% Black. I mean, racist policing is absolutely one part of the equation, but unfortunately, it's not the only part. So that's kind of, you know, a basic overview of how our probation system is not so different from the other aspects of our criminal justice system.
Thank you for that. And just talk a little bit about kind of the current status of the bill. And also I want to give a shout out to our ASL interpreter, Kat. Thank you so much for joining us again on this Monday night. And for those who are just joining us, we're talking about Senate Bill 913. It's a bill focusing on probation, on some changes to the current probation system here in PA, with Dolly Prabhu from the Abolitionist Law Center and Liz Randol from the ACLU of PA. Can you give us a quick update on where the current legislation stands and what is the likelihood, you know, of it making it to the governor's desk, you know, in this current legislative cycle?
Sure. So the Senate Bill 913 passed by a very large majority in the Senate a few months ago. So it is still, so for those who may not be super familiar with the legislative process, a bill has to pass through the one chamber. In this instance, it already passed through the Senate, and then it has to go through the House. And in order to get to the floor of the House, it has to come out of and get a vote out of committee. So this bill is currently waiting for consideration in the House Judiciary Committee. And it has not yet been scheduled for a vote, but we have been encouraging people to contact their state reps, so not their senators at this point. They've already voted on it. But if people are interested and if you have a relationship with your state representative in the House, in the Pennsylvania State House, give them a call and ask them to oppose Senate Bill 913. I'm not sure. I mean, I think some of our advocacy and our pushback on the bill has probably slowed the, so I mean, we don't have a complete obvious insight into all of the reasons and all of the thinking that goes into the decisions about which bills get scheduled for a committee vote. But I think, our concern is that if the bill runs in the House Judiciary Committee, it may actually get amended to be even worse. And so I think the idea that we could improve the bill through amendments, whether it's in committee or on the House floor, is probably unrealistic, shall I say. And so, but it really depends. I think it's important to note sometimes that in addition to there being partisan conflict in the legislature, that people forget sometimes that there's competition and sometimes conflict between the Republicans, so the majority parties in both of the chambers. So if the House Republicans sort of see this as a Senate Republican priority, they may not care. They might have something else that's on their priority list. And so we just want to make sure that make sure that legislators know that there are a lot of us out here, a lot of organizations that are opposing this bill. We have a letter that we circulated, and thank you to One Hood for being a co-signer of that letter in opposition to, and ALC, of course, in opposition to Senate Bill 913. So there's 55 organizations, the majority of which are Pennsylvania-based, grassroots and directly impacted organizations. And so we just want to make sure that the legislators hear from us. It's really important that they know that people are watching this and are paying attention. And if you have personal stories, we always, whether you've been on probation specifically, if you've had a family member, a friend, a loved one, those always are far more important for, and I'm sure you've covered this a million times, but these are, the personal stories are the ones that are the most meaningful to legislators, because it gives them a sense of how this bill would affect their constituents and why it's so important. This stuff sounds academic as we've been talking about it, but this is causing a lot of real damage to a lot of people in Pennsylvania. And I think legislators, unless they hear how that translates, how all this word salad translates into the damage this system does to real people in the Commonwealth, then we just need to make sure that they hear that. And I think they hear it more easily when it comes from constituents with their stories in particular.
Yeah, thank you about that. And as we wrap up, I'll go start with you, Dolly, as well as you, Liz. What are some of the things a probation bill you would like to see in the future, right? We know that it's not going to be a perfect bill, but if you could, draft your perfect bill with the caveat that probation is still a thing, in this perfect bill, what would be some of the provisions that you would like to see?
Yeah, sure. So I'll just list some specific things maybe that in the world of probation that absolutely should be focused on whenever we're talking about probation reform. The first is obviously probation detainers. They need to be reined in for sure. The way their use is absolutely rampant, and there's no oversight whatsoever, and judges and how they use them. And even county to county, it varies so much with who is allowed to, or who actually detains people, even though it's technically the judge. The detainers are issued by parole officers sometimes, and it's just such a messy process. But the end result is all this pretrial incarceration, this needless pretrial incarceration. So detainers absolutely need to be addressed. Other things that a probation bill could do is propose caps on probation, so hard caps, limiting the length of probation. Prohibit the use of split sentences and of stacked sentences. And then I guess the last thing I'll mention, because I could go on forever, is that incarcerating people for technical violations, so for non-criminal activity, essentially, that should be prohibited outright. if not that, then that power should be significantly scaled back. Although, incarcerating people for non-criminal activities already that should not be permissible in any context. So those are the things that I think a good probation bill would accomplish. And I'll pass it to Liz now, because I know that she has a better summation of, in the abstract, what we should be looking for in like a good criminal justice reform bill.
Yeah, so just abstract, I think, we try to summarize, or at least look at the big questions about how we should look at any, what we would be looking for in any bill. And so really the ones that Dolly mentioned up front, which are some of the specifics, but, I'll just say first, those would be the, whether or not does the bill have reforms that respond to the main drivers of mass supervision and incarceration in Pennsylvania. And so what Dolly had mentioned, whether it was detainers, caps on the probation sentences, reducing the amount of time that someone is on probation. So, when I had mentioned the provisions for automatic termination, even if you didn't cap probation, you could automatically terminate it if people had not violated and had met the terms of their probation. Limiting or restricting or prohibiting incarceration for technical violations. And let's see. So really needs to deal with some of those, at least one of those elements decently. The other is making sure that it's a non-carceral bill. So in other words, does the bill include any new provisions that could lock more people up? It seems pretty simple, but this bill, we would argue, does. And the third is making sure that the reforms are clear and easy to follow and easy to implement. I think sometimes because there are so many, say, voices in some of these bills, they're trying to accommodate a lot of different interests and a lot of people's requests, that what happens is you get a bill that is so clunky and so confusing and so difficult to navigate that the reforms that you are offering are not easy for anybody to figure out how to get to them, like how to implement those reforms. And so, we've often said, and I'll just speak for the ACLU, that sometimes we would take a smaller, less seismic change. So we'd rather take a smaller change that is very easy to understand and makes a very clear change in the current statute than trying to do something really big and really bold if it means that it's also complicated. So we would prefer things that are so that probation officers, for example, could actually follow the amount of time, like Dolly had mentioned earlier, that there are these review conferences that people are entitled to under Senate Bill 913 that will require that people have their probation reviewed by a judge. But all of the process to get there is so insane. I mean, it's almost impossible to determine how many months when you become eligible for your review, that I don't know who is supposed to be keeping track of that. Is it the person on probation? Is it probably not their defense counsel, because often people are not represented by counsel at that stage? And the probation officers, they have an average, I think in Pennsylvania, it's somewhere around 140, 150 people on their caseload at any given time. That's crazy. So in any case, so that's just sort of one example of making sure that some of those changes those reforms are easy to explain, easy to follow, and to implement.
Thank you all, so much for that. And I think it really helps to put the legislation in context of what people wanted to see from it, but also what people are still hoping to have in the future. Because again, it's always, tedious sometimes to really have to go and do the work, read those bills, and be like, hey, you kind of messed up here. So I do thank you both for your advocacy and for coming on this holiday, Malcolm X's birthday, to come and just talk to us about like probation and the needs to change for this bill. So thank you so much, Dolly from the Abolitionist Law Center and Liz from the ACLU of Pennsylvania. I hope you enjoy the rest of your Monday.
Thank you.
Thanks so much.
And so that was, one of our legislative visits. Sometimes we have the politicians themselves coming on and talking about the bills they put up. Other times we have organizers and advocates who work around legislation to come and do these legislative visits, so we know what bills to pay attention to in this ever-changing, fast-paced world. So I'll turn it back over to you, Takari.
Yeah, I want to thank Dolly and Liz once again for joining us for that very enlightening conversation about the broader probation system, but also a specific piece of legislation that is currently moving through the Pennsylvania General Assembly. So thank you so much for joining us tonight. We have another full week of programming. Last night we had Ariane Abney on the Sunday night sit down. And we're going to be continuing to do those half an hour kind of deep dives into the various candidates running for office. So stay tuned to see who will be coming up on upcoming episodes of the Sunday night sit down as well. And as we move from February into March, we'll also, begin, our candidate forum series. We've been a little bit hesitant to go full bore and rolling it out and launching it because there's still a ton of uncertainty, with the upcoming election, with the state Supreme Court, looking at the congressional maps and these proposed changed timelines for petitioning. Petitioning is supposed to be happening right now. We're actually supposed to be in the second week of petitioning, but we're in a process where petitioning may not start until sometime in March, which really changes, the timeline in a variety of ways. We would like to, really have a much better sense of, who's out circulating petitions, who's actually running on the ballot, before, we roll out our forums. But we know this is a very unusual year, so we will modify our calendar however we need to make sure that you have your opportunity to meet the various candidates who will be on the ballot, not only on April 5th, but also on what looks to still be on May 17th, which is the primary election. April 5th, of course, being the special election in the 24th and 19th legislative districts, and then the primary election where we have, a whole cacophony of candidates running from U.S. Senate, Lieutenant Governor, Governor, of course, State Senate, and State House. So thank you again to Dolly and Liz for joining us tonight, for giving us such great information about a piece of legislation that has been talked about a lot in the local media, and as well as talked about a lot statewide and amongst the activist community. So back to you, Miracle.
Yes, and again, thanks so much to our special guest. And they mentioned about over policing not being the only thing driving mass incarceration. And so tomorrow, we are having a rally at 2 p.m. at the City County building here in Pittsburgh with a call to, defend and protect Black lives, to invest in Black lives, to fund Black lives. A part of that with the understanding that the communities that have the most resources are the safest, and the communities that have the most resources are the ones that don't have to resort to survival crimes in order to make sure there's shelter, food on the table, a place to lay down at night, and having money in the pockets. And so when we're talking about not only changing the way probation works, but how our society and culture engages Black people, to know that 66% of people who are detained are Black, and 43% who are on supervision are Black in a region where people, only 13% of the population. We know that happens for a reason. And one of those reasons is, economics. One of those reasons is anti-Blackness. One of those reasons are the lack of, the intentional, I would say, political and policy failures that have come through Black communities and have defunded Black communities and that have defunded Black schools and have locked Black people out of jobs and opportunities. And so tomorrow, we're going to ask that you join us at 2 p.m. at the City County building. If you're not able to, do not worry, because you'll be live streaming the rally to provide better access support for folks. So again, that's going to be Tuesdays at 2. Wednesday, we're talking about This Week in White Supremacy at 6 p.m. And on Thursday, we are going to be back here for Ask a Black Lawyer, where we're talking about how to protect your art and your legacy. So if you're an artist, if you're creative, if you're putting stuff out into the universe, you want to make sure you're making sure that it can't be stolen or taken from you. You want to make sure it doesn't end up in one of these Super Bowl ads or one of these political ads. Like, what can you do to prevent that from happening? We're going to be talking with 3 lawyers Thursday at 7 p.m. So again, a lot of great programming for the Waterhood Media Network, and we always invite you to stay tuned. If you liked learning about SB 913, SB 913 today, we again encourage you to look at the comments, to take action, to go like and subscribe to our YouTube page to make sure you're staying up to date with all the current information. And with that, I'll turn it back over to Kahari.
Thanks again. I want to thank Liz and Dolly for joining us tonight, representing the ACLU and Abolitionist Law Center. Also, I want to thank our ASL interpreters, Cameron and Kat, for their wonderful work. And again, be sure to tune in this Sunday at 7 p.m. for the Sunday night sit down. We'll be sending out an announcement about who our special guest will be this Sunday, and then next Monday. We will be continuing our programming. We will confirm midweek whether it will be the first candidate forum of our candidate forum series, or we will have one more episode where we focus on a piece of policy or a current event. We're just going to be watching over the next couple of days what happens at the state Supreme Court and what happens in Harrisburg before we finalize our schedule for next week. So on behalf of our, again, I want to thank our ASL interpreters, Cameron and Kat. I want to thank Liz and Dolly, and for my courageous co-host, Miracle Jones. And on behalf of the whole One Hood Media team and One Hood Power team, this is Kahari Mosley signing off until Sunday night at 7. Thank you so much. Stay engaged in the process, stay informed, and most importantly, stay safe. Thank you. Have a good night.